Good evening and a very warm welcome on behalf of the Jewish Historical Society of England Leeds branch and on behalf of MILIM to this evening's presentation. Welcome wherever you are in the UK and indeed wherever you are in the world. Our series of online talks and conversations continues with our guest, Dr. Chelsea Sambells, and I'll introduce Chelsea in just a moment. Please do ask questions. This is possible by typing whatever you'd like to ask into the Q&A facility on your screen. We will try our best to get through as many of your questions as we can. Let me also draw your attention to the chat facility. This will allow you to send a message to all of the other participants on this webinar, should you wish to do so. And finally, this event is being recorded. It will appear on our website at milim.org.uk in the next couple of days. There you'll find recordings of other past events, as well as details of our future programme for which you can book tickets. And so to our speaker this evening. Dr. Chelsea Sambells is a research fellow in modern European history at the University of Huddersfield and is head of research at the Holocaust Centre North. Her first book, due to be published next year, is called The Exceptional Evacuation, and it focuses on the wartime child evacuations to Switzerland to offer new insights into European humanitarian efforts between 1939 and 1945. Chelsea's research chiefly studies how governments and NGOs protect and treat refugees and children during war. She was recently published in the European History Quarterly. This evening, she is speaking about the little-known legacies of the Nuremberg Trials. So, Chelsea, thank you for being our guest this evening. We're very excited to hear what you have to say. So, without further ado, over to you.
Thank you very much. I'm delighted to be here. I will now share my screen. And hopefully everyone can see this.
It's good.
Yep.
Great, thank you. So thank you for this lovely introduction, Jonathan and Alan, for organizing it and inviting me here this evening. I'm truly delighted to be here. So tonight I'm going to tell you a little bit about the Nuremberg Trials and their incredible impact on human rights, genocide, clinical research, in the fields of translation and interpretation. It's quite a mixed bag tonight, but my goal is to focus on the lesser known or lesser understood legacies of the trials. I hope there's a little something for everyone in this talk. There we go. There we go. Most of us know about the Nuremberg Trials because of this man, the president of the Reichstag, Hermann Göring. The second in command of the Reich, Hitler's right-hand man, a celebrated Air Force pilot, and a leader of the prestigious Luftwaffe. Some might also remember him as the big Nazi, weighing in at 120 kilograms and rumored to be a morphine addict. After Göring surrendered himself to the Americans in May 1945, he was immediately put on a diet and, because of his influence over other inmates, was eventually put into solitary confinement. Court reporters at first assumed Göring, the face of the Nuremberg trials, was simply a buffoon or a fanatical Nazi. But as he spent a week in the witness box, that became far from the truth. He was suave and adept, maneuvering through European politics like a well-oiled machine. According to one journalist, Göring, quote, defended himself adroitly with subtle challenge to the reasoning instincts of his audience. He was given free rein to say more or less what he liked. But let's not forget, he was also a criminal. The notorious Hunger Plan, which sought to starve millions of people under German occupation, along with captured Soviet soldiers, was the brainchild of Göring's offices, and according to historian Timothy Schneider, resulted in 4.2 million deaths of Russians, Belarusians, and Ukrainians. And importantly, Göring himself admitted that he was the one who came up with the idea of concentration camps. Göring was one Nazi within a sea of Nazis who were put to trial at Nuremberg. So what were the Nuremberg trials? The first trial began in November 1945 and lasted 210 days. It persecuted 24 of the most important and high-profile figures of the Third Reich. 22 of those received sentences. Two others, Robert Ley, he had committed suicide before the trial began, and the mental and physical health of Gustav Krupp von Bohlen and Halbach had prevented his being tried. So 22 at the end were given sentences. The Nuremberg trials set the groundwork for the International Courts of Justice, the Universal Declaration of Human Rights, 2 Geneva Conventions, amongst other countless legacies. The first trial, featuring Hermann Goering, was conducted by the International Military Tribunal, which represented France, Britain, the United States, and Russia. But there were other trials too. Few are aware that the Nuremberg Trials is actually a term that represents or encompasses 13 trials, although mistakenly. The first was the famous trial with Goering, held by the IMT. And historically, that overshadows the 12 subsequent trials that took place at Nuremberg. They were not tried by an international court like the IMT, but by an American military court called the Nuremberg Military Tribunal. That's because Nuremberg sat within the American zone of occupation, and importantly, administering American concepts of justice in Germany was a sure way to gain foothold in post-war Europe, particularly given the uncertainties brewing with the Soviet allies. The other 12 trials that took place between December of 1946 and April 1949 prosecuted Nazis from various arms of the Third Reich. Notable industrialists such as Field Marshal Erich Milch, I.G. Farben, Oswald Pohl, Friedrich Flick, and Krupp were given special attention for their uses of forced labor to achieve certain economic outputs. For example, Flick had employed around 48,000 slave laborers, some 80% of which did not survive. But doctors, lawyers, judges, army personnel, they were all prosecuted too. And feel free to ask me further questions about any of these trials. But let's spend a moment on the first trial, the famous one, held by the International Military Tribunal. Some of the key criticisms that were leveled at the IMT at the time and subsequently include, and excuse my poor Latin, nullum crimen sine lege, no crime without law. Belief that people could not face punishment for acts that were not explicitly illegal at the time that they were committed. This obviously is a major issue for the legitimacy of the Nuremberg trials. We must remember that Nazi Germany enacted numerous laws that deprived German citizens of their rights. For example, many of you probably heard about Nuremberg race laws. They were enacted in 1935. They defined Jews as persons with at least one Jewish grandparent and declared explicitly that a Jew cannot be a citizen of the Reich, he cannot exercise the right to vote, he cannot occupy public office. This meant that Jews no longer had many of the rights as other citizens, including rights to healthcare, education, etc. So if this was law, even if we find it today morally repugnant and dangerous even, then how could any Nazi perpetrator be persecuted for following the law of the time? We will touch on this again later. Victor's justice. Judges were not from neutral countries or included any anti-Nazi German jurists. The judges were all in fact provided a pre-allotted role. The USA, with Robert Justice Jackson as chief prosecutor, took responsibility for conspiracy, and the British, led by Hartley Shawcross, for crimes against peace. The Soviets dealt with war crimes and crimes against humanity as far as the Eastern Front was concerned, while the French took responsibility for crimes in Western Europe. Not a single judge represented a country that had not been victimized or attacked by the Third Reich or its allies. And the final criticism, that the Allies were not considering the same crimes that they themselves might have committed. The Allies committed a number of war crimes against Nazi Germany and others, for which they themselves would never stand trial. For example, the area bombing campaigns by the USAAF and RAF, particularly on Hamburg and Dresden. In July 1943, one night of Allied bombing on Hamburg killed 37,000 people, when compared with the 43,000 that were killed in the Blitz over an 8-month period. Also, the Soviets were of course, culpable of war crimes against Poland in 1939 and 1940, where its forces had not so secretly signed the Molotov-Ribbentrop Pact. This led to plunder, rape, other crimes against Poles, including the unlawful detention of thousands in Soviet gulags. So as you can see, there's some very legitimate criticisms of the IMT. And a major criticism of the Nuremberg trials was that it mistakenly focused on the motivations of those at the top rather than at the bottom. And let me just explain this one a little bit more. After the Nuremberg trials, there were tens of thousands of trials of average Germans within East and West German courts, as well as in Austria. One of the fundamental flaws of the German system, the German legal system, which also pervaded the International Military Tribunal and the Nuremberg trials, was its focus on denying a racist motivation. The German penal code stipulated that a first-degree murder must be the product of a killer's base motives, such as hatred, bloodlust, greed. This was different from intent. Homicidal intent was clearly demonstrated when Nazi officials or policemen killed thousands of people, but that's not a motive. And even participation in state-sponsored mass murder was not considered a motive itself. Accordingly, the plea, "I was only obeying orders," referred only to intent rather than to motive, and was vehemently espoused and defended by a broad spectrum of perpetrators, from Field Marshal Wilhelm Keitel in 1945 to SS Obersturmbannführer Adolf Eichmann in 1961 to the lowliest German policeman. But many scholars today, such as Donald Bloxham, draw attention to the failures of the Nuremberg Trials and the German and Austrian legal systems to properly interrogate the Nazi system itself. This is a big field of criticism. I could write a PhD thesis on this, so I'm only going to touch on it briefly here. But let's hear what Donald Bloxham has to say. He says that these legal and moral self-defense strategies, I was only obeying orders, contributed to an image of the final solution that was literally ordered from the top down. Initiative or improvisation in killing was the last thing to be admitted, and as that disappeared from view, so too did the national and local variations of the Holocaust, to be replaced with an impression of a much more uniform genocide. In the last 20 to 30 years, we've seen a big shift in Holocaust studies as they begin to recognize that the Nuremberg Trials failed what the Nuremberg Trials failed to recognize: the very important role that mid-level managers of the Holocaust played in shaping and executing genocidal policies. Scholars such as Christopher Browning, Daniel Lee, Alex Kay have produced incredible studies on average Germans who became leaders of the mass killings that took place in the Holocaust. And I promise this is the last text-heavy slide. Historians obviously have a lot to say about the trials, both as a historical phenomenon itself and as a method for documenting history. For example, notable and celebrated historian A.J.P. Taylor said in his book, The Origins of the Second World War, the evidence of which there is too much, is that collected for the trials of war criminals in Nuremberg. Though these documents look imposing in their endless volumes, they are dangerous materials for a historian to use. They were collected hastily and almost at random as a basis for lawyers' briefs. This is not how historians would proceed. The lawyer aims to make a case, the historian wishes to understand the situation. The evidence which convinces lawyers often fails to satisfy us. Our methods seem singularly imprecise to them. But even lawyers must now have qualms about the evidence at Nuremberg. The documents were chosen not only to demonstrate the war guilt of the men on trial, but to conceal that of the prosecuting powers. Given the four-power tribunal, the only possible course was to assume the sole guilt of Germany in advance. The verdict preceded the tribunal, and the documents were brought in to sustain a conclusion which had already been settled. This is quite a damning statement, and in some ways, quite true. But it should also be taken with a grain of salt. At a time when German society and the international community wanted to move on from war and embrace happier peacetime activities, the Nuremberg Trials became an invaluable historical record for future generations. No one today can claim ignorance to the atrocities or the scale of the Holocaust. And a great part of that is due to the extensive research, legal proceedings, and publicity of the Nuremberg Trials. What was identified as legally relevant at that time is itself a relevant historical finding and shows us today how the world in 1945 to 1949 conceived criminality, genocide, and human rights. This is particularly fascinating given that there were no international laws to protect civilians in war by the time the Second World War broke out. Let me say that again. There were no international laws to protect civilians in war by the time the Second World War broke out. How, might you ask? This leads us to the first great legacy of the Nuremberg Trials, defining a universal concept of human rights. Modern rules of war are only 150 years in the making. Some claim they started with Abraham Lincoln's enactment of the Lieber Code in 1863, which tried to limit the military actions of his Union forces by permitting certain humanitarian measures to be taken, upon the condition that they didn't contradict any military objectives, of course. But I would argue that it actually began in 1864 on the other side of the ocean, when the red cross on the white background, the opposite of the Swiss flag, came to symbolize a neutral protective party helping another in conflict. This is known as the Red Cross. Today, the international community has developed a fairly robust series of international laws that explicitly aim to limit the effects of armed conflict for humanitarian reasons. Although, of course, reinforcing these laws is an entirely different matter, as we see today in Ukraine. The critical problem before the Second World War was that individuals were subject to the laws of their nations, but could not claim rights under international law since they were not subjects of international law. Looking at it from the other way around, as objects of international law, individual status did not differ from a state's territory or its other sovereign possessions. Individuals thus belonged to the state. And let's take a moment there, pause to consider what would happen if you lost your citizenship and became stateless, such as refugees or Jews stripped of their citizenship, as was legal in pre-war Germany. So, thus, before 1939, individuals were subject to the laws of their nations, but not to international law, a rather subtle but critical difference, you might say. In both the First and Second World Wars, this equated to entirely different treatment between civilians and other groups, such as prisoners of war. For example, sending a receiving post, which remains a cornerstone of human rights today, was not granted to interned, displaced, or detained civilians, but instead these rights existed solely for prisoners of war, POWs. Because the 1907 Hague Convention explicitly stipulated that POWs would, quote, enjoy the privilege of free postage, letters, money orders, and valuables, as well as parcels by post intended for prisoners of war or dispatched by them, shall be exempt from all postal duties. This meant that you could send your husband knitted socks or a food parcel to a POW camp, or ask about your loved one's whereabouts to relevant authorities. Pictured here is the International Committee of the Red Cross's massive systems indexes in Switzerland, which handled 2,000 to 3,000 of letters of inquiry per day during the First World War into the whereabouts of lost, fallen, or captured soldiers. By the end of the First World War, the International Committee of the Red Cross had compiled nearly 5 million index cards and forwarded nearly 2 million individual parcels and 1,813 wagon loads of collective relief supplies. Today, these files have been digitized and are even searchable online. The Third Geneva Convention in 1929 expanded the rights of POWs to even further to include the establishment of official information bureau by all belligerent nations and the coordinated relief of prisoners, whereby properly accredited professionals should both monitor camp operations and distribute relief. In practical terms, this meant that POW camps during the Second World War were regularly inspected by Red Cross officials, whereas many concentration camps were not subject to humanitarian inspections. But the Third Geneva Convention, again, neglected to define civilian rights. In 1934, the world came very, very close to providing civilians international rights at the 15th International Conference of the Red Cross and Red Crescent Societies in Tokyo. The international community vigorously tried to clearly define the rights of civilians as those people within a territory of a belligerent, or as individuals in the power of the enemy in occupied territories. But the Tokyo draft was not signed nor implemented with any legal authority in any of the years that followed. And by the outbreak of the Second World War, it was shelved, reconsidered, and finally made legitimate in the Fourth Geneva Convention of 1949. Thus, by the outbreak of the Second World War, there were no international laws to protect civilians in war. But then, the Nuremberg Trials. Nuremberg was chosen mostly for practical reasons, although the irony of choosing Nuremberg was not lost on the Allies. It had a courthouse, the Palace of Justice, that needed substantial renovations, with a working prison that could hold up to 1,200 inmates, and even an airstrip for delegates, the media, and other important persons to use. But it was also the spiritual center of the Third Reich, having hosted the famous annual Nuremberg rallies. Nuremberg was the Bavarian capital. It spawned the rise of the Third Reich by hosting massive Nazi party propaganda rallies in the 1920s and 1930s. Even though Munich is often considered the home of Nazism and its ideology, Hitler himself chose Nuremberg as the Nazi spiritual home. Nuremberg had previously been the center of the imperial empire, and to Hitler, it represented the Germany that he was creating. The great street, Grosse Strasse, of the Nuremberg rally grounds was even designed to line up with Nuremberg Castle to signify a direct and symbolic link to the great medieval Germany and the new Germany the Nazis were creating. How does one persecute various Nazis for various crimes in a digestible and strategic way? The International Military Tribunal, the agreement between France, Britain, the US, and Russia to persecute and punish war criminals in a court of law, decided upon 4 categories of crimes. We have number 1, conspiracy to commit charges 2, 3, and 4 is listed here. 2, crimes against peace, just defined as participation in the planning and waging of war, of aggression in violation of numerous international treaties. Number 3, war crimes, defined as violations of the internationally agreed upon rules for waging war. And 4, crimes against humanity, namely murder, extermination, enslavement, deportation, and other inhumane acts committed against any civilian population before or during war, persecution on political, racial, or religious grounds, and execution of or in connection with any crime within the jurisdiction of the tribunal, whether or not in violation of domestic law of the country where perpetrated. Fairly comprehensive. Each defendant was tried for one or even all 4 of the categories based upon the available evidence, often gathered from captured German records. Fortunately for justice, the Nazis were pedantic record keepers. This beautiful home, once owned by a German industrialist who supported the Nazi regime, is in the southern suburbs of Berlin, called Wannsee. Arguably, the most outstanding discovery of evidence for the trials was by German lawyer Robert Kempner, who had scoured the German Foreign Office and uncovered the record of one 90-minute meeting at the Wannsee House in South Berlin in January of 1942. One of the attendees was the Undersecretary of the Ministry of Foreign Affairs, Martin Luther, who, despite being told repeatedly by the meeting's organizer, Adolf Eichmann, that he should destroy the meeting minutes after reading them, he had kept a record of the infamous meeting. If Martin Luther had not done so, we would likely have never known about this meeting. This lakeside villa became infamously known for hosting this Wannsee conference, when high-ranking Nazi officials formally decided on the genocidal policies of the final solution to the Jewish question, otherwise known as the Holocaust. This was when gas chambers were identified as the principal means for mass extermination, and when 6 major death camps were formally identified as the locations for this genocide. Thus, such documents were critical to the legal proceedings at the Nuremberg Trials. But we've become distracted from our main point. Given that Germany's legal system enacted special laws to support their discriminatory policies, and given that civilians were only subject to national, not international laws, then how could the international community persecute Nazis for crimes against their own citizens? All of the defendants, but one, Albert Speer, submitted pleas of not guilty. While on the stand, nearly all of them said they were simply following orders. In the subsequent Nuremberg trials, this too was the defense. The IMT, the judges, ultimately rejected perpetrators' arguments that they had been following official policy and thus was actually legally permissible under national law. Instead, the judges returned to a small but powerful introduction from the Hague Convention, referred to as Martens Clause, which states, bear with me, until a more complete code of the laws of war has been issued, the high contracting parties deem it expedient to declare that, in cases not included in the regulations adopted by them, the inhabitants and belligerents remain under the protection and rule of the principle of the law of nations, as they result from the usages established among civilized peoples, from the laws of humanity and the dictates of the public conscience. This rather vague and imprecise sentence was sufficient grounds for these judges, admittedly the victors of war, to argue that Germany had contradicted the basic human rights afforded by all civilians by the laws of humanity. And this, ladies and gentlemen, is when it all changed. While the Nuremberg trials sought to punish these criminals for their cruel treatment of civilians, it actually achieved so much more. It was a dramatic legal and conceptual transformation that internationalized human rights. Importantly, it eliminated that subtle but critical difference discussed earlier. Individuals were no longer subject to the laws of their nations, but subject to a higher authority of international law that guarantees their human rights. These human rights would then be enshrined in further international laws, most notably the Universal Declaration of Human Rights in 1948. Another critical legacy of the Nuremberg Trials was that genocide became a crime. This might sound ridiculous, particularly when one pauses and considers the multiple genocides that occurred before the Holocaust. The term genocide was actually created by Robert Lemkin, a Polish-born lawyer who served as an advisor to Chief Prosecutor Robert Justice Jackson. He is credited with coining the term genocide in 1944 to describe the Nazis' planned extermination of Jews. The word is an amalgam of genos, the Greek word for tribe or race, and side, Latin for killings. Lemkin, who lost nearly 50 relatives in the Holocaust, defined genocide as a coordinated plan of different actions aimed at the destruction of essential foundations of the life of national groups with the aim of annihilating the groups themselves. As a result of the Nuremberg Trials, the 1948 Geneva Convention enshrined genocide within its laws as a way to deter governments or political groups from undertaking acts with the intent to destroy in whole or in part a national, ethnic, racial, or religious group. And if one pauses to consider this meaning of genocide, then it can be evidenced in other major historical contexts or themes, including colonialism, imperialism, slavery, etc. After the collapse of communism in the 1990s, when suppressed nationalism of multiple ethnic groups was unleashed in places like Yugoslavia and Bosnia, the United Nations investigated evidence of war crimes for the first time since Nuremberg. Notably, rape was recognized as a crime against humanity for the first time in the aftermath of the Bosnian Civil War. To date, genocides have occurred in Uganda, Cambodia, Rwanda, Somalia, Bosnia, China, and many other nations. Also, the legal process to administer justice can extend into decades. For example, on the 24th of March, 2016, Radovan Karadzic, the former Bosnian Serb leader named the Butcher of Bosnia, now in his early 70s, was found guilty of genocide, war crimes, and crimes against humanity by the United Nations Tribunal for his actions in 1995 in Srebrenica. He was sentenced to 40 years imprisonment, more than many Nazi war criminals from Nuremberg. Now let's move on to another notable legacy of the Nuremberg Trials. The Doctors' Trials. The Doctors' Trials charged scientists and doctors with crimes against humanity for their euthanasia programs that killed those that they deemed unworthy of life, alongside other crimes for conducting extensive medical experiments upon concentration camp inmates. This would lead to new laws around medical ethics, which I shall explain. Some Nazi doctors argued that they were ordered by their government to investigate how to overcome common ailments to improve the life expectancies of German pilots and soldiers. For example, there were experiments about hypothermia as they related to German pilots who crash landed into the North Sea. My apologies for the unsavory details, so I will try to keep this only as explicit as is really required. For example, at Auschwitz, they plunged Jewish inmates into large containers of icy water for lengthy periods of time. They monitored their core temperatures with rectal thermometers, and then, upon removing the inmates from these icy baths, they tried multiple methods to rewarm them, including plunging them into hot water or laying them beside naked women. Such terrible experiments clearly demonstrate that the health of the medical subjects was not at all to be protected or preserved. And at the same time, such experiments were clearly guided by a belief that it was somehow going to help with hypothermia treatments in the future. However, this approach was not the case everywhere. At Ravensbrück camp, which was the female camp, the only female perpetrator to stand trial was Dr. Herta Oberhäuser. She carried out experiments which included killing children in order to extract organs and remove limbs, as well as deliberately inflicting painful wounds by rubbing in rust and dirt. Horrific details were given by one witness who survived the experiments on her leg muscles and even displayed her disfigurement to the court. Oberhäuser was initially given a 20-year prison sentence, but it was commuted to 10 years, and in 1952, a mere 5 years after receiving the 20-year sentence, she was released for good behavior. Even more astonishingly, she returned to medical practice for a few years, which was only cut short when a former prisoner of Ravensbrück concentration camp recognized her. Her medical license was then withdrawn. According to a leading historian of Ravensbrück, Kate Docking at Hamburg. The experiments at Ravensbrück were increasingly violent and extreme, particularly in the period of 1942 to 1944, due to the desire of doctors stationed there, including Oberhäuser, to compete with each other and to impress Himmler, their boss. Importantly, the doctors' trial exposed that there was no single blueprint for medical research. With regards to the hypothermia experiments, the American prosecution teams argued that forcing concentration camp victims to die in frigid and icy baths for medical research failed to honor doctors' Hippocratic oath and underlying ethics to do no harm to patients. But several German doctors, the defense, of course, argued that no international law or informal statement differentiated between legal and illegal human experimentation. In fact, the German doctors claimed that their experiments differed little from those conducted before the war by German and American scientists. And we must remember that this is at a time when euthanasia had not just taken place in Nazi Germany, but also within the United States. For example, in 1931, the Illinois Homeopathic Medicine Association began lobbying for the right to euthanize, quote, imbeciles and other, quote, defectives. By 1938, the Euthanasia Society of America was founded. Although the USA moved towards sterilization rather than euthanasia, some 60,000 people were sterilized in 32 states during the 20th century. So the point being, the United States and the American prosecution team did not have a great track record. This forced the American prosecution team to find the best and most ethical doctor to testify research physiology and whose wartime scientific interests corresponded to Nazi research interests. Dr. Andrew Ivy and Dr. Leo Alexander were called as witnesses for the prosecution, and Dr. Ivy's testimony lasted 4 days, the longest of the trial. Dr. Ivy claimed he personally followed 3 common sense rules when experimenting on human subjects, such as avoiding all unnecessary physical and mental suffering and injury to patients, or conducting trials on the basis of animal experimentation first. While such guidelines were evidence that medical experiments could be undertaken ethically, during cross-examination, Ivy acknowledged that there were no written principles of research in the United States or elsewhere before December 1946, and even more so, that the principles adopted by the American Medical Association were expressly formulated for the doctor's trial. In April 1947, Dr. Alexander submitted a memorandum to the United States Council for War Crimes. This memo outlines 6 points that defined legitimate medical research. The trial's verdict of August 19th reiterated almost all of these points in a section entitled Permissible Medical Experiments. It also revised the original 6 points to 10 into what then these 10 points became known as the Nuremberg Code. This, ladies and gentlemen, is another major legacy of the Nuremberg Trials. Extraordinarily, the Nuremberg Code has not been officially adopted in its entirety as law by any nation or as ethics by any major medical association. Nonetheless, its influence on global human rights law and medical ethics has been profound. The concept of informed consent for medical experimentation became recognized as a cornerstone of international clinical research ethics. Also, the code stipulated the need for medical experiments to be undertaken for the good of society and not for random or unnecessary purposes, as was the case with Dr. Oberhäuser's experiments in Ravensbrück. The Nuremberg Code is the basis of the international ethical guidelines for biomedical research involving human subjects, the most recent guidelines put forth by the World Health Organization and the Council for International Organizations of Medical Sciences. And of course, it is also an important part of ensuring that citizens of today's democracies, even in the midst of global pandemics, remain entitled to informed consent for all medical needs, including vaccinations. And we have our final lesser known legacy of the Nuremberg Trials. Many do not realize how important Nuremberg Trials were to the professions of translation and interpretation. While this might seem rather trivial in comparison to medical research ethics, trust me, it's not. Before the trials began, the Allied nations agreed that any war crimes trials needed to be carried out fairly and expeditiously. To achieve this, the proceedings needed to be simultaneously accessible in English, French, Russian for the judges, representing, as I said, the United States, Britain, France, and Russia, and also in German for the defendants and the defense counsel. Not an easy task. Translation is performed on written works, changing a source text into another language. Translation usually allows for edits and time for consideration and reference. Because the witness testimonies, empirical evidence in court proceedings taking place over 10 months or 210 days, all had to be translated into 4 languages. This resulted in 42 volumes of published transcripts. This eye-watering amount of information gave the Nuremberg Trials the nickname, the trial of 6 million words. Meanwhile, interpretation, unlike translation, is performed on the spoken word. And although there are different types of interpretation, it is often performed without any time to consult sources. In order for the trials to take place as quickly as possible, simultaneous translation, meaning that an interpreter waits for a unit of meaning and then delivers that unit of meaning into another language, is what was required. And we must, of course, recognize that there is an understandable lag of about 6 to 8 seconds between what was said and what was then translated. An American linguist named Leon Dostert, Eisenhower's personal translator, was the head of the IMT's translation division. He had an office at the Pentagon from which he began to recruit interpreters, mainly for English and German, but for other languages as well. The French and the Russians were to be responsible for providing their own language staff, and the United States was to share the English language staff with the British. In the end, the Americans did most of the heavy lifting in terms of recruiting, housing, and also paying the interpreters and translators. After a few short months of, really more weeks, of recruiting, 12 interpreters were assigned to each day of the trial. One additional team was kept in reserve while another team had the day off. Thus, interpreters worked 2 days on and 1 day off. Some interpreters who spoke Yiddish and Polish were called in occasionally to translate victim statements. Meanwhile, IBM's International Translator System, which had been in operation since the 1920s in Geneva, was installed within the courthouse in Nuremberg just 3 weeks before the trial began. Over 600 headphones were hooked up to an elaborate system of electronics so that everyone, from judges to defendants to journalists, could hear the proceedings in one of the 4 languages. Channel 1 was the verbatim proceeding, Channel 2 was English, 3 Russian, 4 French, 5 German. The Nuremberg Trials' goals for fairness and rapidity would not have been possible without this technology. Interpreters were positioned in the courtroom close to the defendants, the legal teams, and the judges. This allowed them to see the faces of those who spoke, which in turn gave them better access to the nuance and the emotion of the trials. The job itself required a calm demeanor, good hearing and speaking, the ability to focus, and the awareness of linguistic nuance. Often interpreters needed more than one term to describe something, but secondary or tertiary words to convey meanings. Interpreters were generally between the ages of 25 and 45 years old. Younger individuals often lacked vocabulary, while older individuals lacked the sustained focus needed for important interpretation. Some objected to women interpreting as male speakers, while men were considered to have better voices than women. Astonishingly, interpreters worked for 85-minute shifts on the microphone. In comparison, today, United Nations interpreters work for no longer than 20 minutes without a break. Auxiliary interpreters also assisted the proceedings. To ensure consistent translation, all lawyers, defendants, and witnesses who spoke were asked to slow their pace to 60 to 80 words per minute. You'll notice the slow signs on the desks there in that photo. This was monitored by an auxiliary interpreter or monitor who operated a signal system of yellow and red lights. The monitor would flash a yellow light if a speaker needed to slow down, while a red light would indicate that he or she needed to interrupt the proceedings for coughing spells or interpreter replacement, or if a phrase or passage was inaudible and needed to be repeated. This signal light system, first used in Nuremberg, is still in place today at the UN. Here we have Captain McIntosh of the British Army translating from French into English, while Margot Bortland translates from German into English, and Lieutenant Ernest Peter Uberhall monitors the translations. There were a few problems with this deliberate system of interpreting and translating. The Nazis used certain German words as euphemisms or to hide meanings. Expulsion in place of extermination is a popular English equivalent. These meanings were often not clear to the interpreters until more context was provided, which resulted in confusing or inconsistent vocabularies. The content of the trial was clearly very distressing too, and often interpreters struggled to repeat the words or phrases describing murderous acts. Finally, speaking for 85 minutes straight often resulted in coughing fits and interruptions. The German defendants reacted differently to the interpretations. Some tried to use flawed interpretation and plea bargaining. Many of the defendants spoke English already or other languages, so they used the delay for interpretation to gather their thoughts or gain time or slow the proceedings. Ultimately, many thought that the better the interpretation, the better their chances of survival. And after reading a few transcripts of the trials, not all of them, mind you, because that's 42 volumes and 6 million words, as we know. But I've read a few, and I've actually found that the translation and interpretation of defendants' words actually forced them on occasion to really clarify their meanings. This is valuable to me as a historian because it means that vocabulary cannot be taken for granted. For example, we have above here an excerpt between Justice Jackson and Goering. And we'll see that Justice Jackson is referring in his question to Goering about a previous interrogation and what Goering said in this previous interrogation. And Goering responds, "The interrogation must have been recorded entirely incorrectly. That is the very reason why I refused from the beginning to give my oath to these interrogations before I've been able to look carefully at the German transcript and determine whether it was correctly understood and translated. Only once, and that was on the part of the Russian delegation, was a completely correct transcript submitted to me. I signed it page by page and thereby acknowledged it." And then he goes on to clarify his point. "I should like to put it right. If this had been entirely conducted in English or in German, I doubt that there would have been that deeper level of understanding. And that's why I think the Nuremberg Trials from a translation standpoint is so very effective and so very interesting, because it really forced everyone to really defend their positions and what terms they used, why and how." And the work of such interpreters and translators was not solely limited to the famous Nuremberg trials. Because Holocaust survivors often spoke multiple languages, but were not Nazis themselves, their multilingualism was invaluable to the military governments who urgently needed to reestablish legal courts and other civil systems in the chaos of post-war Germany. For example, the survivors that our charity works with at the Holocaust Center North, Ibby Nil and Eugene Black, both worked as interpreters for the British military. Both met their future spouses through this important work and then migrated to Britain after the war. In light of the mass atrocities and tremendous violations of human rights that occurred throughout wartime Europe, the Nuremberg trials sought to administer justice to the Nazi politicians, administrators, and bureaucrats that allowed such murderous policies to flourish. How they achieved this has, and should continue to be, heavily criticized, dissected, and used as a point of reference for all international criminal courts in the future. But they also achieved remarkable legacies, including a new universal concept of human rights, a criminal classification of genocide, a new international agreements for clinical research ethics, along with formulating new methods around the practicalities of how to administer that justice in multilingual conflict zones. Even today, the hundreds of translators and interpreters who work for the United Nations follow many of the same rules and procedures that were first created at Nuremberg. The legacy here is enormous. Hermann Goering, the face of the Nazi trials, committed suicide the night before his execution was to be carried out. According to journalist R.W. Cooper, who published the very first book on the trials in 1947, quote, "Goering, mocking to the end, took cyanide of potassium in his cell as the hour approached and was dead by the time the doctors were called. The findings of the Board of Inquiry claimed that he had the cyanide capsule with him the entire time of the trial, which fit in well enough with the little ironical smile that we saw in the doc." Thank you for your attention.
Thank you so much, Chelsea. That was fascinating, really insightful. If you have questions for Chelsea, please put them into the Q&A in the few minutes we have left this evening. You say there was no international law, but there was the Hague Convention. So what was the Hague Convention if it wasn't international law?
Well, the Hague Convention for civilians, so there were international laws, certainly for other things, the ways in which certain governments had to conduct themselves, the way that certain economic policies and treaties had to be followed. Absolutely, there were rules of law. However, not with regards to protecting civilians in war. And that's the real difference. So that civilians, not POWs, but just civilians, simple people, there was no international law to protect them, which is why it became such a difficult situation after the Holocaust to figure out how to charge these criminals. And they had to go back to that. It's a really, when you think about it, it's quite a feeble thing that they did. They went back to this Martens Clause and the Hague Conventions, and it's so weak. It's so non-descriptive, it's not explicit, it's not transparent. But you can see that through the talk that there's all those strides up in the Tokyo draft, and there was true attempts to try and get to that place where civilians would be protected by the rules of law. But unfortunately, it wasn't to be by 1939.
Okay, we have some questions from our audience now. So Linda Rosen asks, for the other 12 trials run by the Americans, were they scrupulously fair, or did the Americans decide whether they wanted to use any of the criminals, for example, taking Werner von Braun and others with knowledge, which clearly they did?
Yeah, I mean, were they fair? Really? It's a really good question. I don't think you can say that they were fair. They certainly, and I wouldn't also say that the IMT was particularly fair either. But what they tried to do is that idea that you're taking a sort of kaleidoscope of the Nazi hierarchy and putting them on trial. What I find astonishing is that there's clearly a desperate attempt in that post-war period to sort of get on with life. And so a lot of these war criminals, really terrible people who committed a huge amount of violence and torture and atrocities against innocent and helpless civilians, would be let off with 5-10-year sentences. Sometimes, even not that, they wouldn't even be either they weren't even indicted, or they weren't actually sentenced to what I would imagine to be a commensurate amount of punishment for what they actually did. So, but it was at that time, everybody's trying to move on, and you can't, and to be fair, they couldn't put the entire country on trial. They just didn't have the court system to be able to handle that, even if they tried.
Malcolm Sender is interested in whether the Russians were involved in Nuremberg.
They were certainly in the International Military Tribunal. The Russians also conducted their own war crimes trials even in as early as 1943. And these were a little bit farcical. The Americans, at least, they had more of a transparent legal system. And I'm saying that also as a Westerner, and I'm saying that with that sort of Eurocentric viewpoint. But the war crimes trials that the Soviets enacted, there was even a stronger presumption of guilt. And there was that tendency to be more like the show trials from Stalin, Stalin's Great Terror and era. So there were some Soviet trials, but they were even more biased at the beginning.
We have a couple of questions about the current situation in Ukraine. Firstly, John Cowell asks, Russia has recently alleged that the Ukrainians use civilians and children as human shields in order to defend their actions against civilian targets. Did this arise during Nuremberg, and have you any comment on it now? And also Harry Sambels, I think you might know him. What is your reaction to the comment that Putin is a war criminal for his action in Ukraine? Does this have a basis in the legacy of Nuremberg?
Yes, okay. So the first question around using children and victims.
Well, alleging that children are used as human shields.
Human shields. When it comes to the Nuremberg trials, I mean, there was certainly there was certainly an awareness that children and women and the civilians were all that they were, of course, targeted and systematically murdered in various different kinds of ways. I think what that question is trying to lead to is this sort of sense that you've got attempts to use ideas of humanitarian measures as a way to protect military forces, right? And I think that's what that question gets to. And when it comes to the war crimes of the Third Reich, that's not something that I'm aware that they even tried to do. They didn't even care if they were using women and children to protect them. Certainly not after 1941. Maybe in the beginning, but certainly not after 1941 that I'm aware of, that they're sort of using children to protect military advances or anything, or using, no, they didn't, they were that cutthroat. They didn't care at that point in time. With regards to Mr. Harry Sambell's question of Putin as a war criminal, he has launched an aggressive war against a democratic nation based upon baseless information about it being a Nazified area. Ukraine is led by a democratically elected Jewish leader. So I think that Putin is a war criminal, and I think certainly he's broken the rules by invading sovereign and democratically in a democratic land. So yes.
We have a question from Noreen Plen. Where did the lawyer Lauterpacht fit into the Nuremberg trials? He also introduced a new law at the time. Is that a name you're familiar with?
Not that I'm familiar with. I'm so sorry, I don't know that detail. Okay. Lauterpacht. I can find out.
Well, maybe that's a good place to start. We have no more questions from our audience. So there we must leave it. That's been absolutely fascinating, Chelsea. Thank you for being our guest. And to say thank you, I'll send you some of my photographs of Magen David Adom. This is the Israeli ambulance service in action. So I hope you'll enjoy that.
Absolutely. Thank you so much for having me tonight. I've had such a great time. So thank you.
It's our pleasure. Now, just a few words about our future program before we leave you. On the 4th of April, Joshua Rubinstein joins us from Harvard to tell us about his excellent book, The Last Days of Stalin. And then the following week, on the 11th of April, we welcome Pam Fox, who is speaking about the Jewish hotels and guest houses of Bournemouth. Please do visit our website at milim.org.uk to book your tickets and to make sure that you sign up for our newsletter and you don't miss anything. I've not turned my lights on, that's why I look so dark. It remains for me to thank our guest, Dr. Chelsea Sambles. Once again, thank you so much, Chelsea. And I'm looking forward to seeing